Good morning, everyone. I'm Brian Landry of Saul Ewing, LLP, and I'll be moderating this second episode of the Financial Poise Intellectual Property 101 series entitled Copyrights, Patents, and Trademarks, Oh My. Financial Poise seeks to provide practical and entertaining education for participants with a variety of backgrounds. And joining me today are Alan Grafman of All Media Ventures, Patrick Riley of Spike Dynamics, and David Perry of Blank Rome LLP. You can read our bios on slides 75 to 78. Neither Financial Poise nor we intend this to be an infomercial, so you don't have to listen to me read bios. If you want more information about us, just look at our slides. I'll call your attention to slides that are relevant to whatever we're talking about, so you can take notes if you'd like. Don't worry if you're listening but not watching this webinar, you'll be just fine because the slides are not critical. Thank you to our co-producer, the National Law Review. You can read more about the National Law Review on slide 3. And Financial Poise webinars are supported in part by sponsors. The sponsors for this webinar are Type to Learn and Max Asset. More information is available on slide 4. One last thing before we begin. Slide 5 contains a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate advice. Without further ado, here we go. Patrick, what is a copyright and what rights does it give to the owner?
Well, copyright will protect an expression of an idea, not the idea itself, but any expression of it in fixed media or even transient media, if the work itself is in fixed media. So it's automatically provided to an author. It's known as a natural right. An author is used to describe anyone who creates the work, whether it's music or dance or painting. We've heard them technically, the legal term is author. So if they're the original work of the authorship, it can be then used by them. It can be reproduced. It can be distribute copies. You can perform it publicly. You can display the work, and no one can do that without your permission. Now, copyrights are properties, so they can be assigned, in other words, sold. Then the other copyright holder now has the rights.
Great. David, what kind of things can be protected under copyright law?
Well, following up on what Patrick said, copyright can protect everything from literary works to dramatic works, musical and artistic works, paintings, poetry, novels, movies and songs. Also, it can protect software, protect your website. Your company's website is a work of authorship, even architectural design. So authors, therefore, can be writers, composers, visual artists. They could be choreographers, filmmakers, architects, software programmers, and developers. Like Patrick was saying, however, it does not protect simple statements and facts or ideas, but rather only expression.
Right. So, Alan, if I have an idea in my head, is it automatically copyrighted?
So thank you, Brian. So has Patrick and Dave covered? No, it's not. Ideas cannot be copyrighted. For an idea to be copyrighted, it needs to be put into fixed form. It needs to be original, and those rights are for the author originator, and we'll get to what that means a little bit later. But no, thinking of something or even expressing it like a song in the shower or singing to a friend does not provide, because it hasn't been fixed in a tangible form.
Patrick, so what does a copyright allow you to do?
Well, it allows the author or the assignee to do it themselves or to authorize someone else to distribute the work. And it can be accomplished through licensing, assigning, which means transfer of ownership, and other forms of distribution. So basically, it's the right to copy it.
And Alan, what do you need to do in order to get copyright protection? You talked about how it needs to be, it needs to be fixed in a tangible medium. Is there anything beyond that?
So the 2 points in answer to your question, Brian, it does need to be fixed in a tangible form, and that automatically grants certain rights. There's additional protections, but for now, we're focused on the fact that once it's expressed and put into a fixed format, you have copyright protections, and we'll get to more of that in a bit.
Great. So to follow up on Alan's answer, Patrick, what are some examples of tangible media?
That's a critical question sometimes. I mean, the obvious tangible media are books, motion pictures, fine art, maps, computer programs, sculptural works, musical compositions, architectural drawings. But I had a client who painted trees. Copyright Office accepted it. Paint on a tree was accepted as a tangible media. Examples of works that are not fixed are choreographic works that have not been recorded. There is a notation method to record a choreographic work and file it with the Copyright Office. Contemporaneous speeches have not been recorded. So anything that's not put into a fixed media.
Right. And one thing to keep in mind, which increasingly is relevant these days, is that even though we may think of things we type as just being electrons, if you're approaching it from a computer science perspective, it's saved on disk, so that it entitles a lot of works that are originally typed, as most things are these days, to copyright protection. David, how does a court determine what material in a compilation or a derivative work receives protection? And maybe just to back up a little bit from there, can you explain what those terms mean?
Right. Well, a compilation is a work comprised of pre-existing works. There is a definition under the Copyright Act. It's either comprised of pre-existing protectable individual works, or it could be comprised of individual elements that are in and of themselves not protectable, but together with your original selection and arrangement, you could have a protectable compilation. A derivative work is an adaptation or abridgment or subsequent version of a pre-existing work. And basically, as I mentioned, with respect to compilation, you have to have an original selection and arrangement, and that can be a little bit of a murky concept. But you could, for example, have take a best of 2024 top 15 hits of the year. You could have a musical work like that is a compilation of pre-existing songs, and maybe you've arranged it, or maybe it's thematically arranged. The derivative work protects only the new and original authorship over and above the original work, and it can't just be mere editing or minor changes. It has to actually be something where your additional authorship is in and of itself something that passes, that has the modicum of originality.
Yeah, and as I was posing that question to you, I was reminded that the Copyright Act, relative to other statutes for IP, tends to have a lot more definitions relative to the Patent Act or the Lanham Act for trademarks. So there's definitely a lot of special words that are always worth consulting and are often misunderstood by people. So when in doubt, consult the statute. The Copyright Office has a set of circulars which are really quite helpful, and even better, consult an attorney if you have questions. Alan, so generally the creator of a work owns the copyright. Who owns the work when an employee creates the work? And what does it mean to be, again, another one of these special terms, a work for hire?
So Brian, this is extremely relevant and shows up in the news often. And if everyone on this audience understands the difference, they will save themselves a lot of grief, because employees creating work that is commissioned by their employer have no rights unless the employer grants them rights. So in short, work for hire is just exactly what it sounds like. It is work that your employer or a friend paid you, and that work for hire is not yours. You don't have rights to it, and it's really important. And by the way, even more recently, On February the 1st in the Wall Street Journal, there was an article, it's a bird, it's a plane, it's a Superman lawsuit. These lawsuits show up every year around these types of issues. The audience may recall that the two creators, Schuster and Siegel, sold the original Superman character and story to DC for $130 70 years ago, and we'll get to the term of copyright a little bit later. But the point is, you have no rights if it is a work for hire. The person or entity that hired you has all the rights, and it is something that everyone will be mindful if you are a creator.
Great. And just to put a little gloss on that, this is one of the rather technical areas of copyright where the work made for hire is defined by the statute, and between that and court decisions, it's basically one prong of it has been held to basically require that it be a W-2 employee as opposed to an independent contractor. So it does get fairly technical. But it also has some real significance. We'll talk about copyright term later, as Alan mentioned. But the term for the copyright differs whether it's, I guess, a natural author versus a situation where the author is the employer because it's a work made for hire. So whether you're filing your own application or if you're ever seeking to get registration, you're wondering why your attorney is drilling down on this, it's because it actually makes a big or a significant difference in terms of the copyright registration application. So you need to figure it out up front. Patrick, we've talked a lot about, or some about registration. Do I have to register a copyright?
No, but it's a very prudent thing to do. And if you're being looked at as a merger and acquisition candidate, the people looking at you are going to really want to know that you've buttoned up your copyright. So it creates a public record, so it's solid notice to the world to what your work is, and you have a copyright claim on it, okay? And one thing here, if somebody signs a consultant agreement and says that you'll get the copyright, that's fine, but actually get them to assign it on a written document so that that's locked down, that there's no argument about that. Two, it enables you to file a lawsuit in federal court. You can't walk into federal court on a copyright infringement claim unless you have registration. Now, often judges will accept an application date as sufficient, so application number, but play it safe, file within 3 months of publishing the work, and then you're good to go. It also is evidence your copyright is valid. It's assumed to be valid if the Copyright Office has accepted it. That's very important, so you don't have to waste legal time and money proving that it's valid. And then fourthly, if you file early enough, it enables you to claim statutory damages and attorney's fees. And I'll tell you, attorney's fees are scary. So if you file your registration within 3 months of publishing your work, or prior to infringement, don't forget that, but it's still very prudent to file within 3 months of publication. Then you've given the judge a really free hand on giving you a favorable judgment with statutory damages and your attorney's fees being reimbursed.
Great. David, just throw a somewhat random question. I believe there's still a circuit split in terms of exactly whether you need an application or a registration. Do you happen to?
I don't really. My counsel is that the circuit split's been resolved. That
Oh, okay.
I think Ruth Bader Ginsburg, in her opinion, basically made it clear you need a registration. And at this point, I guess to Patrick's point, I certainly wouldn't feel very comfortable. I never feel comfortable even merely with a pending application. If I'm really in a bind and I did not have a registration, I do it on an expedited basis. So you can do a rush filing. The government will charge you. I think the fee now to do an expedited registration takes the normal fee of $80 or something like that, add another $850 to get them to go quickly. And you're going to end up paying that money, because I assume if you're about to go into litigation, $850 is really, no great shakes to just get it, have that registration, and don't run into the problems that Patrick's referring to.
Great, thank you.
Well, thank you for
Alan,
that
so-
correction, Brian and Alan.
So Alan, how long does copyright protection last?
So I'm going to make 3 points on this. The first is everything is post 1977. So there is a fixed term. I believe it's, in fact, I'm certain it's 70 years. It's the author's lifetime plus 70 years from the author's death. That's for the author for original works. For works made for hire, as I believe Brian pointed a moment ago, the copyright lasts for 95 to 120 years from publication. And that's for, I'll call them corporate, made for hire types of works. And the third point I'm going to make is, again, in this article I referenced from the Wall Street Journal. And by the way, the attorney who is doing this, I'm friendly with, and I speak with him periodically. It's different overseas. This lawsuit on behalf of the creators of Superman, this lawsuit is using different terms. By terms, I mean different lengths of copyright protection based in the UK, which is slightly different, and based in Canada. So the point is, if you're an author, it's from death plus 70 years. If it's corporate, it's from publication plus 95 to 120 years. And overseas, it can be different.
As Alan touched upon briefly, there's been several copyright regimes in effect within the United States. And because of the long term or the long duration of copyright, you potentially can be looking back to easily pre-1976 works. So there are tables online. I know Cornell has a pretty good one where you kind of go down one side and say, when do I think, looking at when the work was created or published, and does a good job of pointing you in the right direction. David, so like copyright registration, copyright notice is no longer required for protection. This is a post-1976 change that was made. Do copyright owners receive any benefit from providing that notice?
Yeah, a copyright notice, which is what people are used to seeing with the C symbol in a circle, the year of first publication, and a identification of the owner. The copyright notice does put people literally on notice, and I think we usually would say it prevents the innocent infringer, prevents somebody from saying they were unaware that you were claiming copyright ownership. So it's a best practice. It's not required. Sometimes people will put a copyright notice on the front page of a work, so to speak, maybe on the last page. Some people will put it on every page. That sometimes is a little bit overkill. And to your earlier point, if you were working on a situation or your company owned a work that dated back so far into a period when it was created before the current Copyright Act, you still sometimes have a situation where it was created at an era where copyright notice was a requirement, and you could find yourself digging back to see whether copyright notice was used on a work, more than half a century ago, to litigate that matter. But today, no longer required, but still beneficial.
So Alan, I've heard of the concept of fair use. Can you tell me a bit about that?
So fair use is super interesting, and it's been the subject of a lot of controversy, particularly in music these days. But the short version is you're allowed to use copyrighted material without permission if you're using it in certain circumstances, if you're using it for parody, satire, public commentary, editorials to a certain degree. Fair use is just what it sounds like. It's limited. And another word that is often used, which we're not going to spend a lot of time on, is transformative. That's a word that is hard to define. You're best keeping the use limited, so you clearly fall into that category. But again, you do not need permission of a copyright holder for limited purposes such as satire, parody, commentary.
Great. So David, how does a court determine whether an accused use is fair use?
The courts today apply 4 factors, which are actually listed in the Copyright Act. They are codified in the Act. It's a balancing of 4 factors. No one of the factors is deemed to be dispositive. So depending on the situation, you look at all 4. The first being the purpose and character of the use that is being made. 2, the nature of the copyrighted work. 3, the amount and the substantiality of the portion of the work that you have taken. So in some cases, you may take a huge, measurable quantity. In other cases, you may take a small quantity, but the substantiality could be quite impactful, quite important. And the 4th factor, the impact on the marketplace for the copyrighted work or the plaintiff's work. So it's a balancing of those 4 factors, and typically you'll see, even up to the US Supreme Court, you'll see them run through each factor, and in many cases, as was heard yesterday in a big decision that came out yesterday in the first probably AI copyright case, they will literally determine which side wins which factor, and then, as it was yesterday, it was 2 and 2, and then they picked essentially a winner on a particular motion.
Do you want to talk a little bit more about that?
Yeah, yesterday, the decision in the West v. Ross case, basically, ironically, Westlaw, which makes legal research software that every attorney knows and every law student knows. Another company, Ross, fashioned its own system, apparently used AI to sort of harvest head notes. These are sort of bits and pieces of summaries throughout Westlaw software that we all rely on. And the argument from the defendant was that it was fair use, that their software had been transformative, that they sort of borrowed but improved, borrowed and changed. And long story short, the court went through all 4 factors and determined that what they had done was infringement of Westlaw's software, that the various pieces were protectable, and it was definitively not fair use. So like Alan said, it's a hot topic always. It's very interesting, and it's almost unfailingly shades of gray.
Yeah.
Hey, Brian, I want to stay with this just for a
Yeah, go
second,
for it.
because as David touched on, anything, my understanding, and by the way, I'm the only non-attorney, but I'll say I'm also the only business person, but that would be pejorative. I'm the only non-attorney on this panel. So I'm pretty confident that if the product is 100% AI, it is not, there is not a creator, there is not an author, and it is not copyrightable. If it is touched by human hands and it is manipulated in some demonstrable fashion, it can be copyrighted. And those are important factors going forward. Something that is 100% produced and not touched by human hands cannot be copyrighted. And there's decisions coming down frequently on this topic. And I'm going to stand my ground unless I've got it wrong. Dave, Patrick, Brian,
No,
have I
you're
got it
right. The Copyright Office literally just issued their latest policy statement on this, I think, last week. And it's hard to summarize in short. You kind of have to read it from beginning to end, but you can use AI in creating your work that is protectable. You cannot yet get any kind of protection in prompts. There are a lot of people arguing that the creativity of your prompts, of your searches, the prompting that you use to create the AI work is such a creative and difficult exercise. That argument so far is not winning the day. So yeah, the Copyright Act was already relatively antiquated to modern technology, and now with AI is fast struggling to keep up.
That's a really good point. Thank you for adding that. Patrick, before we leave copyrights, how are statutory damages calculated?
Well, the court has the authorization if the finding is the infringement, and then the statutory damages are calculated. Basic range is $750,000 to $30,000 per work infringed. If the court finds that the infringer is not aware, then it could be $200 per work, if the court so chooses. But for willful infringement, the court can go up to $150,000 per work infringed. 150,000 per work infringed.
One last point before we leave this, there is an ongoing dispute or debate within the law in terms of exactly how the statute of limitations gets applied in the copyright space. There's a 3-year statute of limitation, but the debate is what happens if you don't become aware of the infringement until after that. The Supreme Court had a case, I believe it was last term, ultimately kind of punted on that issue, although some of the justices, including Justice Gorsuch, had opined that we really should just get rid of the discovery, or there was no basis for the discovery rule. But it is still something that's being debated, differs from court to court. All the more reason where if you think there's an issue with copyright that you have rights in, promptly consult with an attorney, because if you wait too long, you very well could find yourself out of luck. All right, let's pivot to trademarks. So Alan, what does trademark law protect?
So trademarks are primarily for 2 distinct entities, groups of entities. It's to protect the consumer, so the consumer is not confused when they go to buy a product. So the consumer understands that the product they're buying is the product they think they're buying. So that's to remove confusion from the marketplace, to prevent confusion in the marketplace. The other is to allow the creator of products or services to benefit from that creation. So it allows the owners of trademarks and logos to benefit solely and completely as they wish from the use of those trademarks. So again, prevent confusion for consumers and allow the benefit for the trademark and logo owners.
Great. Dave, what is the difference between goods and services? And can you provide some examples of either?
The trademark office basically, and the law basically, has taken all of the products and services that we make in our economy and put them into different buckets. Goods are essentially things, for all intents and purposes, that are tangible items, things you can hold. There are some exceptions. Downloadable software, downloadable music is actually categorized as a good. Contrast that with services, everything from traditional service, legal services, accounting services, consulting services, and now in this day and age, serving up software, hosting, SaaS, software as a service, those are considered services. So when you apply for a trademark, you are really required to pick the bucket and identify where you fall.
Absolutely. And I believe it was Dave that mentioned earlier how the Copyright Act that we're operating under is straining a bit with age, dating back from 1976. The classifications that the USPTO and other offices use are the NICE classifications, which I think go back to the 1950s, if I'm right. But as a practitioner, this is definitely an area where it really does show its age. As David mentioned, you can really fit almost anything into it, but there definitely are a lot of historic anachronisms where the USPTO, for example, makes a really hard distinction between goods made of metal and goods made of plastic, even though nowadays lots of things are composites, and we can find ourselves having some interesting conversations with the examining attorneys on, just tell me where you want me to put this, but what they propose may not always make sense. And then similarly in the software space, there is that hard distinction between downloadable software and non-downloadable software. And so it's important to really, think about it and make sure you understand what type of software you're going to be providing. Because if you push it into the wrong bucket going initially your application, it can be hard, if not impossible, to get it the other way to where it should be. Patrick, aside from goods and services, what else can be trademarked?
Well, slogans such as "Just Do It," colors such as Louboutin has red bottoms on the bottom of their very expensive shoes. You might have seen those on TV. I've never seen one in the flesh. Then sounds like the NBC jingle, characters like Donald Duck or Harry Potter, and packaging like the Coke bottle, which actually was the first package that was recognized as trademarkable. But the distinctive shape of the Coke bottle is trademarked, is registered for trademark.
David, so if I created a particularly unique functional product design, can I get trademark rights in that?
No, trademarks, like copyrights, will not protect functionality. You can have to fight pretty hard to persuade the trademark office that it's serving a source identifying function, as we would say. But functionality is definitely a third rail when it comes to trademark, as it is for copyright. Compare with patent, where you kind of need it.
Yeah. And there's definitely been cases where the trademark side of the office shows that they do know how to search patents. And so that's one area where both applicants and patent attorneys need to be careful, because you can say, you make certain statements in your patent applications that end up coming back to bite you on the trademark side if you're then trying to claim some sort of distinctiveness. So Alan, if I have a domain name, do I still need a trademark?
Yes, and actually I have a story. So they're separate. Domain names and trademarks are separate entities. Just because you have a domain name does not give you trademark protection. And years ago, I had the domain name for Conan the Barbarian. And I heard from the people who owned it. And they were slightly flabbergasted, as was Universal that had the movie distribution rights. They were flabbergasted that I was able to get it, the domain. What they didn't know is that their agent had hired me to do some business development, and I had gone ahead. So I gave it up. But it just goes to show that just because you have a domain name, you don't have the trademark protection. And because you have the trademark, you may not actually be able to control the domain. So they are separate is the takeaway.
So Patrick, if a competitor recently ran an advertisement describing their product as similar to mine by using my registered trademark, have they infringed?
Generally, that would be safe to do under the doctrine of fair use. It's good faith use of a term by a third party to describe its goods and services. So it's generally covered by the good faith doctrine.
Okay. And I should note here that there's an entire body of law relating to advertisement that goes beyond, or is related to, but goes beyond trademarks. So that definitely can get to be a pretty nuanced area of law.
Well,
Right.
let me add, I've had
Yeah.
a lot of clients tell me, oh, this is fair use, isn't it? And my attitude is very skeptical. I don't like to assure a client, oh yeah, you're covered by fair use, no problem, because it's a complex decision.
Yeah. Yeah, and always the question of, how much is it going to cost to get the final answer. Dave, so if I've been using my business name for quite some time, is there a need to get a trademark registration?
Well, whether it's their business name or whether it's the name for a product, registration isn't required. It simply is not required. However, it does provide, presumption of validity, gives you nationwide rights, and it, I guess from a practical standpoint, puts you on the map and creates sort of a do not fly zone that will probably make it, if anything, more likely that other people will not encroach. So I've worked with some clients who had tons of trademark filings, and ironically, the one that they never did was their company name, even after 50 years. But that's a little bit unusual. So
Yeah.
in any event, it's not required, but it sure is a best practice, whether it's your company name, assuming by the question that it's a company name that is out there as the identification of the source. Sometimes questions come up about corporate names, back end sort of LLC names that only see the light of day, maybe on a contract or something like that. That typically might not be registered because it's not consumer facing per se.
And to follow up on what you were saying, one of the really nice benefits of registration at the federal level is that the USPTO is a pretty zealous guardian of the register. So in my experience, both on the brand owner side and then on the person that's applying for a similar mark, is the USPTO will often do a lot of heavy lifting for the owner of a registered mark, perhaps even in situations where the owner might not have thought it was necessarily worth their time and investment. Let's see. So, Alan, if I have a new trademark or service mark that I want to start using, what should I do?
Well, if you have something that you want to trademark, you should trademark it. And I'm going to I'll come back to that in a second, but I once actually had a trademark and I filed an intent to use. This was for a product that I was calling Plumpkins. No one wants to eat prunes, but they're made from plums. So I figured I'm going to really increase people's attraction to prunes by calling them Plumpkins. So I filed an intent to use because I didn't have any commerce. And then I actually bought some jars and I actually went into commerce. And at that point, I ran out of money and I did pursue the better registration, which is, of course, they used in commerce. I actually tried to sell them. So the point is intent to use, you can trademark something, it gets you started. You can do that when you're low on funds or you're just thinking about it and it gets you in the queue. And then if you actually get into commerce, then you have a whole lot more protection.
Right. So Patrick, when can I use the symbols TM, SM, and then that R in a circle?
Well, you can only use the circle R after you've received a federal registration. And by the way, if you use the circle R prematurely, you can lose your rights. So don't do it until so your mark is registered. TM, on the other hand, merely requires actual use in commerce. So that's common law. TM means you're not registered, but you're putting your stake in the ground. And SM can be used by owners of a service mark. That's the first to use the mark on or in connection with a specific service.
And one of the complexities that we've seen is that the restrictions on the R and the circle symbol can vary internationally. So I've at least seen some very prominent brand owners that just take the approach that we're just going to use TM because it's not worth the headache of trying to keep track of, can I use the R on the circle in Belgium or Jordan? It will just be consistent. So David, can I use something similar to another trademark if I add to it or change it enough to make it different?
Well, I guess that's the magic question. The standard for trademark infringement is likelihood of confusion, confusion as to source, sponsorship, or affiliation. So probably a question that any IP lawyer or anyone who does trademark practice on any given day is making a call or being asked to make a call on whether the differences and the changes are enough to distance you from the other mark. And if all of us got it right every day, or if every company got it right every day, I guess we'd have a lot less work to do and a lot less litigation going around. But you can have without to steal Alan's thunder, there are a variety of factors Alan can talk about that go into the analysis. You can have situations where you have identical marks, very different goods or services. And you can have situations where you have identical goods and arguably, differentiated marks. So what goes into creating that distance in that space is really almost the essence of any trademark practitioner's everyday practice.
Great. Alan, do you want to talk about the factors?
Well, Dave touched on it really well. So I like to deal with things in a continuum. So confusion for consumers is as a business person. So if someone came out with a Chobani car, I think, in my view, non-legal, I think they're going to be okay. I don't think people are going to be buying the Chobani car based on the yogurt. But let's take Chiquita. If all of a sudden next to the Chiquita bananas, there were Chiquita plantains, I think that would be pretty confusing. So there are a host of ways to measure that, consumer confusion being the primary pinnacle of the result. But how similar is the product? How strength, how is it differentiated? There's a number of criteria that can go into determining whether a consumer would be confused.
And one of the nuances that can make this very interesting and give people like Dave and I a good amount of work is that marks and the goods and services associated with them often are not static. And a great example of that is Apple Records, which owns the Beatles music catalog, and then Apple Computers, which launched about 2 decades later. In the 1980s, computers didn't really do much with music. But as the iTunes Music Store eventually launched, those two brands started, getting a lot closer to each other, and eventually was the subject of an agreement between the parties to try to to avoid confusion. So, Patrick, can I assign trademark ownership to another person or business?
Yes, you can, as long as you retain sufficient quality control over the products or services.
And David, if someone else is using a trademark that's confusingly similar to my mark, what can I do?
Well, number one, take a breath. Don't make assumptions that you have superior rights. Investigate, analyze, make sure that you have priority. I would say that's the number one first step. Be careful. Business owners, almost as a human instinct, often feel they know their world so well that when they spot what they believe is an encroachment, they view it that way and they assume that they have a superior position. You do not want to be in a position where you sort of get a rude awakening and bark up the wrong tree. So do your diligence. Then you have to make a decision. Is it something worth pursuing? Is it something that I could coexist with if certain changes were made? Is it something that just has to be gotten rid of? Typically in this day and age, lawyers are writing letters and reaching out. We're not typically filing a lawsuit as our first step. Litigation's expensive. There are situations where you might file a suit first and ask questions later. But you make a determination as to what kind of outreach to make. You should think through what kind of outcome you'd like to see. And it's a whole wide spectrum from there as to how that journey goes to address a perceived violation and how two parties might work things out. There's any number of ways that human beings can come up with to solve that problem.
So, Patrick, after I obtain my trademark, whether it's at common law, as we say, based on use, or at through a registration with USPTO, does it expire? Is there any way I can lose it?
Well, those are two different questions. So after you obtain a trademark, it won't expire if you practice diligence. That would be using it in interstate commerce as federal registration. If it's just a state common law right, continuing to use it. And if it's federal, you also have to provide specimens of use between the 5th and 6th year, 9th and 10th, and then every 10 years later, 19 to 20, 29 to 30. But you need also to take an oath that what you're saying is true, that I have continued to use this trademark for these goods and services for this period consistently, with exceptions, like for COVID, there's exceptions, but it's not merely making a statement. It's a statement under oath.
Right. And some other areas or ways you can lose a trademark include abandonment. For example, if you haven't used it, there's a presumption after 3 years of non-use that the mark's abandoned. Genericide is another way that it can happen. There's different examples, but people think about Kleenex instead of facial, or as a noun instead of facial tissue. Kind of the good rule to follow there is that trademarks are adjectives, not nouns. Naked licensing is another way where, let's say that I license my mark to Dave, but I don't have any sort of quality control provision. So he can use it on however he wants. It may be high quality goods, it may be low quality goods. If I don't control that, then the trademark ceases to serve that source identifier and quality identifier that Alan talked about at the very beginning of this topic. Alan, so let's say I have a trademark that's become exceptionally well known. Am I afforded any extra protection for my mark?
So if you are fortunate to own a trademark that is exceptionally well known, yes, you have one could consider an extra band or zone of protection, because again, consumers' protection from buying the wrong good is a primary one of two primary purposes. So anything that diminishes it by blurring the difference or by impugning the trademark is subject to a trademark owner's scrutiny and possible action. So the short answer is yes.
And Dave, what damages can be recovered for trademark infringement?
Typically, three categories: actual damages, if there are damages that you can prove, the defendant's profits or ill-gotten gains, as we sometimes say, punitive damages in cases of willfulness, which typically would be at the judge's or the court's discretion, and attorneys' fees and costs in some cases likewise are recoverable.
Great. I'll come back to you. We're going to pivot now to patents, which we've got about 13 minutes left. And as Alan was pointing out before we started this, patents are certainly a specialized area, quite frankly, as are trademarks and copyrights. So we certainly won't but scratch the surface here, but this will be covered in other Financial Poise webinars. So David, what is a patent and what rights does it give to the owner?
A patent is government protection, legal protection for an invention. It gives you the right to preclude others from making or using or selling the inventive work. The term is 20 years from the date of the application, and typically you're looking at three buckets, three types of patents: utility patents, design patents, plant patents. A utility patent is what probably most people would think of when they think of useful processes, machines, articles of manufacture. Design patents is what people would think of in things that are ornamental or aesthetic, a new and original ornamental design. And of course, plant patents, which would be plant varieties in terms of biological plants.
And different types of patents can exist in the same product. So an iPhone, for example, has design patents directed to the shape as well as the icons and other user interfaces. There's also all sorts of IP or utility patents directed to things really, ranging from the glass to particular software. And of course, there's also trademarks, copyrights, lots of trade secrets in there. So, Alan, how are patent rights different from trade secret protection?
Okay, so we need to talk a little bit about trade secrets. Trade secrets are a competitive advantage that a company has and controls. Other people can have similar trade secrets, but a trade secret can be a marketing plan. It can be a formula. It can be something that your employees are working on that gives you a competitive advantage, that is treated as confidential information, is protected by the corporation, and is instrumental in, or at least could be instrumental in, a company's success. Patents are different. Patents, as we've heard, they need to be non-obvious. They need to protect inventions, and that is very different than a trade secret. So the short version is trade secrets are protected by a company that gives them a business advantage. Patents are issued by the U.S. Patent and Trademark Office, as you've heard. They are for non-obvious new inventions.
And this is definitely an area where discussing with speaking with an attorney can really provide you a benefit. Because as Alan just mentioned, if you disclose a trade secret, then it's no longer secret and you lose that protection. Patent applications are published by default and absent a non-publication request at 18 months after the earliest priority date. So if you put your erstwhile trade secret in a patent application and then it either publishes or grants, now the rest of the world knows about that as part of the bargain. So there can definitely be a lot of strategy in terms of, is this something that we think we can get patent protection on? And if so, do we want to go down that path? Or do we want to try to keep it a trade secret? And a lot of that often comes down to the technology. If it's something that's going to exist in a server rack at your company, then that may be fairly easy to keep as a trade secret. Whereas if it's a purely mechanical product where somebody can see the inner workings just by taking it apart or putting it through a bandsaw, then that's probably a poor candidate for trade secret protection. David, we've talked about copyright and trademark protection. How do patent rights differ relative to those types of IP?
Well, sort of piggybacking off of what Alan was saying and distinguishing between patents and trade secrets, as we've said, trademarks are source identifiers. They identify and harbor the goodwill that people ascribe to a particular product or service. Copyright protects works of authorship, original works of authorship fixed in a tangible medium of expression, as we would say. There can be blur between copyrights and trademarks or any of really all of the areas. And as Alan said, a patent, on the other hand, would be, a novel, non-obvious, inventive step or method or process. So there are a lot of forbidden areas in trademark where trademarks can't protect systems or methods or processes, a patent would. You can have a logo that is a very well-known trademark that may also be so creative as to be copyrightable as well. American Airlines actually a couple of years ago fought the Copyright Office for, I think, probably 3 years trying to get their Eagle logo registered as a copyright, which we would all, of course, recognize as a trademark or service mark. But they fought the Copyright Office for about 3 years, I think, trying to get it to copyright registration and show that it was sufficiently creative as a work of authorship. So,
Hey, David, what would be the benefit if they had the trademark and service mark? What's the benefit?
one of the benefits would be copyright can be a much easier tool for online enforcement than trademarks, for starters. A lot of platforms and a lot of websites, because of the Digital Millennium Copyright Act portion, the Copyright Act will take action almost, I don't want to say effortlessly, but I think Patrick and I would say a lot faster sometimes when you have a copyright tool than trademarks, because a lot of platforms and spaces online, for example, do not want to get into a trademark dispute, but they will perhaps react to a copyright takedown because they have a certain safe harbor conceivably under there. So that's usually when I'm doing both of those things, it's because I'm triangulating and trying to maximize my tools for enforcement scenarios where trademark may put me to the test and copyright might be a quicker and easier tool. And that's the obvious example that comes to mind. I don't know, Patrick.
Okay, so Dave, staying with that,
Yeah.
Did they want just the eagle, or was it American Airlines Eagle?
Oh no, it was the elongated eagle, the more modern logo that I think they now have. And basically the Copyright Office said it was too simple. It was too simple.
Couldn't they have just put American underneath it, or American Airlines?
Well, I don't think they would have had any additional copyright protection with the short phrase American Airlines. So really, they just wanted to protect the work of authorship in the actual eagle design. And it took them a while to persuade the government. And the truth is, if you practice in this area and you're dealing with the Copyright Office, you know it's very subjective.
Did they get it? Did American Airlines
did.
get the protection?
I think they did eventually on their third appeal. I think they did get it. But I've applied for copyrights where the Copyright Office says there is not a modicum of originality. I recently had that with a beach ball, a work that was formed around a beach ball, and the government basically said it's not creative enough. Wasn't a beach ball per se, but you know, was sort of what people think of. So sometimes, as we mentioned, I think before, there's a low bar for copyright, but sometimes you can still fall short of it.
All right. If I may, Brian, put in a
Yeah,
plug.
go for it.
30 seconds. I've often thought that there should be an Office of Protector of the Public Domain, which would protect superfluous copyrights, superfluous trademarks, because it is a feast for a feast for bad actors to gum up the works. And I'm recruiting the three of you and everybody listening for the Office Defender of the Public Good and Order, Public Domain. Thank you. Over and out on that, Brian.
Not a problem. Yeah, so thank you for that really interesting question and Dave's really insightful answer. One, to kind of tie this back to the copyrights, which discussed earlier, I'm sure one of us said that copyrights protect the idea, or don't protect the idea, or instead they protect the expression. And software is kind of a good example where you can have patents that are directed to software, and it might be directed to a method that includes 5 different steps. But in most cases, if you're actually going to implement that in software, it's going to take a lot more than 5 lines of code. And that code, even though it might not be the most exciting thing for anybody to read, is considered a creative work. And therefore, you can have copyright protection that protects against the direct copying of that software, as well as utility protection, or utility patent protection, which have the benefit of protecting against somebody independently picking up, or not independently writing the same algorithm, even though they never saw or had access to the source code. Patrick, in the couple minutes we have left, let's talk about the criteria that you need in order to obtain patent protection.
Well, you have to be patentable subject matter. Laws of nature aren't patentable, nor mathematical equations on their own are not patentable. Then it needs to be new. No one in the yard has seen it before. And in the yard is a purposely nebulous term, but you can argue that in court, what in the art, well, actually with the patent office, how broad is the art that you're looking at? And it needs to be non-obvious. You know, you just can't paint it green or turn it upside down. It's got to be an invention that somebody who's an expert in your field, actually the average practitioner in your field, wouldn't think of. And that's it. Patentable subject matter. Well, it has to have utility too. It has to work. Like they're not taking perpetual motion machine patent applications anymore.
I had one of those cross my desk one time. It was a strange area to find myself in. I think we talked a little bit about kind of the public-private bargain for obtaining patent protection. Can you talk about that and what you need to disclose in order to obtain a patent?
Yeah, well, the word patent, of course, means open. That's the whole definition. You hear about letters patent in the UK, which means it's a letter that can be posted on the wall that I'm the purveyor of fishtails to the crown. So in a patent, as we understand it in this country, it would mean that someone could read it and practice your invention without undue experimentation. So it's one of average skill in the art, can practice the invention, make and use it, make and use it, and it doesn't have to do any bizarre experimentation to get that done.
Great. So let's say we go through the patent office, we get a patent. David, what should you do if you suspect that somebody is infringing on your patent?
Well, I think the general rule that I laid out about investigation is quite important. You really are wise to work with a patent attorney. You need to analyze you need to be very cognizant of your own patent and its claims and the metes and bounds of it. You need to buy, typically do a purchase of, if possible, of the suspected infringement. You need to do an analysis of it. You need to filter it through your claims and specification. And then typically, again, I think it would start with a letter communication, but that's a kind of a big question. There's a lot of steps there. I don't know, Patrick, if you would add any other general guidance there at that moment that the business finds themselves in.
Well, I would point out that if you do a patent search, that's insufficient in that there could be prior art out there that's not filed with the patent office as either an application or a patent. So don't think that if you get through a patent search that you're clean. You have to make sure you do a prior art search, which is much broader.
And to harken back to what Dave said earlier in the trademark perspective, it is definitely helpful in these situations to take a breath, because just like with trademarks, where you may think that you have a superior legal position, that the facts are often more nuanced, and compared to the resources that most applicants have in drafting and filing an application, that the USPTO has in examining an application. Once you get into litigation, particularly where there's a significant amount of damages at stake, as is often the case, the budgets for trying to find prior art are just orders of magnitude larger. There was a great quote a couple of years ago from, I believe it was Brad Smith, who was the general counsel and then became the president of Microsoft, to the effect of they do a prior art search for every patent application that they file, and they are consistently surprised when the USPTO examiners find some piece of prior art that they didn't find, and it has a material impact on the scope of their claims. So it's very difficult to find prior art, or at least all of the prior art, and I would dare say impossible. So it definitely is an iterative process, and as patent attorneys, we always have to be open to the possibility that there's additional prior art that we aren't aware of and may not become aware of until we're very much in a pitched battle. With that, I see we're running slightly over the hour. I believe our next IP 101 focuses more on patents. So if you have questions on that, tune in for our next program. And there's certainly additional series from Financial Poise covering not just patents, but really all other areas of IP in more depth. I do want to thank Patrick, Dave, and Alan. If you have any questions, feel free to reach out to any of us with the information on our slide deck. Thank you, and have a good afternoon.
Thank you.
Thank you.